What does the Hermès MetaBirkins lawsuit mean for NFTs? Imagine buying a digital image of a luxury handbag and wondering if it really belongs to the brand or if it's just a clever imitation. That's exactly what the Hermès MetaBirkins case is about. It's a story about how digital assets, called non-fungible tokens or NFTs, can be protected by laws that usually cover physical products. Hermès sued Mason Rothschild for creating and selling MetaBirkins NFTs. These digital images looked like Hermès' famous Birkin bags but had colorful fox fur added. The court decided that Rothschild's use of the Birkin shape and the name MetaBirkins could confuse buyers into thinking they were buying something from Hermès. This shows that trademark rights, which protect brand names and logos, also apply to digital items like NFTs. The case focused heavily on whether consumers were tricked into thinking the NFTs were linked to Hermès. Evidence showed some buyers believed the NFTs were official Hermès products, which hurt the brand's reputation and control over its image. This means brands need to keep an eye on how their trademarks are used online, especially in the fast-growing world of digital assets. Another important point is that Rothschild had registered the domain name MetaBirkins.com. The court found this was cybersquatting, which is when someone registers a domain name that's similar to a trademark to unfairly attract visitors. This part of the case reminds creators and collectors that even domain names related to NFTs must respect trademark rights. The court also treated MetaBirkins NFTs like physical products. This means that if an NFT mimics or references a well-known brand, it can be subject to the same rules as physical goods. Rothschild argued that his NFTs were artistic commentary, but the court rejected this defense because the NFTs were designed to mislead consumers. This shows that simply claiming artistic intent isn't enough to avoid trademark issues if the work causes confusion. Hermès was awarded damages based on Rothschild's profits from selling the NFTs and for cybersquatting. This demonstrates that brands can seek financial compensation and stop further unauthorized sales. For the broader world of NFTs and technology law, this case signals that brands must actively protect their trademarks in digital spaces. NFT creators should be careful when referencing or imitating brands to avoid legal trouble. The law is now catching up with digital assets, applying traditional trademark rules to protect brand identity online. This case is a clear reminder that NFTs are not immune from intellectual property laws. When digital tokens mimic or trade on the reputation of established brands, they can face legal challenges. It encourages creators to think carefully about how they design and sell NFTs, especially when they involve well-known trademarks. Overall, the Hermès MetaBirkins lawsuit marks a shift in how we understand and enforce intellectual property rights in the digital age.